From outside the Stanley Moss Courthouse, I'm Keely Eure here with Dan Weber for Instant Analysis after the hearing for a motion for a new trial in the Todd McNair NCAA case. Now, before we get into what happened in the hearing and the legalese, we actually want to start with what happened at the end of the hearing, the good news of the day. As we were coming out of the courtroom, we got word that Todd McNair signed a contract with the Tampa Bay Buccaneers. He is now their running backs coach, reunited with Bruce Arians. So good news today. And it was interesting how both sides of both attorneys celebrated that news.
Yeah, I mean, we found out actually during the break, and wanted to kind of give a thumbs up to Todd's attorneys, and they had just heard about it too. Although I think one of them had talked to Todd, and they knew it was coming. But then in walking out, the first people that we ran into were the NCAA attorneys, 3 NCAA attorneys, and Kosta Stoyalkovich is their lead attorney. And he was the third guy. And I said, Kosta, did you hear the news? And he looks at me and says, uh-oh, what? What's the news? I said, no, it's really good news. Todd McNair just got hired by the Tampa Bay Bucks. And the other 2 NCAA attorneys had come in close. And they literally jumped for joy. I think one of them said, oh, we've been talking about that. Did that really happen? I said, yeah, it really happened. Isn't that great? They could not have been happier. It was really kind of a neat moment that after, 4.5 weeks of a really tough trial in the spring and the back and forth, and Todd had to kind of become the bad guy in the NCAA's mind to win the case. They were literally as happy as, of course, Bruce Borlett and Scott Carr and Todd McNair's attorneys were. And then we, got together, and all of the lawyers got together afterwards, and could not have been happier. It was a very neat moment, and it kind of, in the trial, I think there was a little bit of a case of, well, because Bruce Arians was at the Arizona Cardinals when Todd had a contract to work for his old Temple coach in the NFL. And it was, the contract was nixed by the Bidwell family, who just hired Cliff Kingsbury. But Bruce Arians, when he got another head coaching job, which he didn't necessarily think he was going to get or come back, he hires Todd McNair today. And that's, kind of a return, because I know people thought during the original trial, well, if only Bruce Arians could have come in and said, I really wanted to hire Todd McNair, that would have helped Todd's case. Well, whether it helps Todd's case or not, it has Todd coaching in the NFL, and that's about as cool as it gets. But the fact that both sides, both the groups of attorneys could not have been more happy, it really leaves you with a good feeling about how today went.
Yeah, it was such a striking image, because we were in the same exact spot a couple months ago where there was just despair on the look of Todd McNair and his lawyers getting that verdict. And now, a couple months later, you have both sides of attorneys on the same day of this hearing, really excited just for Todd getting that job. And congrats to Todd. Apparently his lawyers told us that he's excited to coach former USC running back Ronald Jones. So a good day in that sense. Yeah,
really good. I mean, just everything about it. I noticed, when I started doing the ghost notes for today, first of all, there's no jury. There are no witnesses. One of the, Scott Carr, one of Todd's attorneys, is sitting in the in the jury box, because there's only room for 2 attorneys, and one of the NCAA attorneys was sitting next to me, in the gallery or whatever we call it, and there was no Todd McNair. And it just made you think, oh, Todd's not here. Yeah. And you don't know at that point, where's Todd? Or is he supposed to be here because it's a motion for a new trial and all that? We didn't know. And then we find out by the first break where he was and what he was doing, and that could not be, any more of a cool day for everybody involved.
Mm-hmm. Now, onto the legalese, if you will. So this was a hearing for a motion for a new trial. There were two things that they were debating in this hearing today. Judge Schaller called it a clash of the titans because both sides were very well prepared in their arguments. So the first thing that they were arguing was whether jury number 2, the foreman of the jury during the trial, whether or not he was biased. It turns out after the case, it came out that he worked for Latham and Watkins, the law firm that originally handled the NCAA's part of the Todd McNair NCAA case. And there's a California statute that says if you are involved in that law firm at all, you're not allowed to be in jury that is involved in that case. So they were arguing whether or not that statute applies to juror number 2. Dan, what did you take away from both arguments?
Well, I mean, obviously Todd's point was that that there are like 30 categories in a statute in the California Civil Procedure that describe these are people that can't be on a jury. For example, a father can't be on a jury for a child, or a husband can't be on a jury for a wife. And an attorney, one of those categories is an attorney can't be on a jury for a case in which his law firm has worked. Now, obviously, Latham and Watkins, I think it's the number 2, it's the second largest law firm in the country. Although when the NCAA said, 3,000 lawyers you can, Judge Schaller interjected and said, I think their website says it's just 2,200. And still, it's the biggest, second biggest law firm in the country. And it was like, well, he couldn't know about the case or he wouldn't have been involved in it or whatever. And that's kind of a different section that's a different description. That would be, if you want to argue, did he know about it or did he inject himself into the case in a way that a juror shouldn't? That would be actual bias. That would be a juror who clearly wanted one side to prevail over the other. According to McNair's attorneys, the only way to judge this is the implied bias, which says if you are in any one of these categories, the very implication is you can't be viewed as unbiased, even if you maybe technically you are. It's just they don't want to get into these kinds of discussions. So like a landlord and a tenant can't be, one or the other can't be in a jury for the other one. There are a number of categories, and an attorney from a firm can't be in the jury. And they argued that, because Latham and Watkins only worked on the appeal in 2015 and 16 over 13 months, even though they had their top lawyer in the whole country, former U.S. Solicitor General Greg Garr, worked on the case and represented him. They're saying that, but they weren't in the case today. Latham and Watkins wasn't involved. This was a Wilkinson law firm out of Washington that was handling this part of the case. And they're saying, nope, Todd's attorneys argued that it's the attorney-client relationship is between the client and the entire law firm through the whole case, and that applied here. And so when they didn't find out about it till Monday, after having jury selection on Thursday and Friday, over the weekend, it's not really clear exactly who came up with. Juror Bruno also said, maybe I'm involved with a law firm that works for the NCAA, and that the NCAA said, maybe they did some work for us. It's not really clear how the discussion went. But apparently the NCAA said, we didn't realize that he worked for Latham and Watkins, who handled the part of the NCAA case. Bruce Borlett and his lawyers said, because that was handled by an appellate attorney, Stuart Essner, who only handles appellate work and wasn't here for the actual trial, they also didn't recall that Latham and Watkins had worked for the NCAA. And then Judge Schaller, who made the ruling that he thought Juror Bruno could be fair-minded and didn't have knowledge of the case and he could go forward, was really applying the actual bias category to Bruno, and he probably should have used the implied bias category. So all three groups involved in vetting Bruno probably didn't quite get it right. So, now the NCAA said, well, they had their chance. Maybe since they missed out on getting him disqualified right away, they don't get another chance.
Yeah.
And as McNair's attorneys argued, well, you guys could have done it too. You guys knew he was working for the NCAA. The NCAA chief legal counsel, who was here almost every day, who clearly would have been in charge of Latham and Watkins working for the NCAA, didn't say a word. So they both said the other guy's partly responsible. And Judge Schaller, I know, is sitting there thinking, yeah, and I'm probably responsible too. So how that goes, I don't think we know.
Yeah, and both of these pillars that they were arguing on, and the first one that we just talked about and the second one we're going to talk about, both of those, if Judge Schaller rules in Todd's favor in either of those, that grants a new trial. Now, we kind of buried the lead a little bit. Judge Schaller is going to weigh on this decision. He did not rule today, so Todd McNair's lawyers expect a decision coming in the next couple days, maybe next week, but there's no decision out of today. But for the second thing that both attorneys were arguing was the question number 3 in the jury questionnaire, whether or not there was a false statement in the findings report. Because the jury said that there were no false statements, Todd McNair's lawyers argue that they essentially did not weigh the evidence properly and thus had a misdecision in the case.
Right. I think you get down to the definition of what was, how do you weigh truth and falsity. The NCAA would like it to be substantially true, but maybe there are some things in there that aren't exactly correct or maybe false. And of course, it always, like it always does in this case, it gets back to the Lloyd Lake Todd McNair phone call. And the way the NCAA characterized it, which was they did not correct the fact that they said that Todd called Lloyd Lake. And the phone records and everything else indicates that was not the way that phone call happened. So Todd's attorney said that's materially false. It's obvious from the NCAA's own reports that they used to, basically convict Todd. There's a contradiction. It's clear from, that they published reports that said Todd did something that he didn't do. And so how can you not say that there were not falsehoods in there? So they wanted to say you should have been able to answer question 3 with, yes, there were some things said by the NCAA, published by the NCAA, that were false about Todd McNair. That still doesn't necessarily mean Todd would win the case, but you wouldn't stop it right there at question 3. Yeah. Were there any false statements about Todd? There were. Clearly there were. The NCAA admits there were, but they say it really doesn't matter because the jury weighed it and said, oh, what we said was substantially true, even if some of the things were, they call them paraphrased. No, they just turned them around. I mean, when you say the guy who made the call, who didn't make the call, you said he did, you're not paraphrasing that. You're flipping it. And so I think that's an interesting question. I don't have a good feeling about, the idea between some false statements or the overall judgment that it was substantially true. I don't think we know how that should go. I just don't know.
Yeah, and the interesting part is that question number 3, it was revealed, it was actually something that Todd McNair's lawyers actually put into that questionnaire. So, I mean, as far as both things that Judge Schaller heard today, where do you think he leans? I mean, it's hard to read Judge Schaller. He is a very fair judge. You get that impression from him. He gave the both sides a lot of time to discuss and argue their position. So, did you get a feel or a gut sense at all where Judge Schaller is leaning?
No, I don't think we did. I don't think the attorneys did. I mean, if it were me and I were, involved in the case on one side or the other, if you had to say maybe he'll come down on the fact that, because he has to blame himself to some extent, that the juror probably should have been disqualified. I mean, I certainly believe that. If I were on the appeals court, I would, reading as little as we have of the case law, it would seem that he should have been disqualified. Yeah. The second part, I don't know that you can rule that the jury's verdict there. I mean, I don't think they would have come to that verdict without juror number 2, Anthony Bruno, kind of making it clear as the foreman and as the only attorney on the jury, that he believed they didn't satisfy, that those weren't a problem. And I think the jury went with him. Had he not been there, had he not been making those representations, I don't think we have any idea how the jury would have decided.
Yeah.
And we know that even in that case, if juror number 2, Bruno, had not gotten the one juror disqualified because they said, oh, there's an English language problem, the vote was 8-4. And that was a mistrial. And so the vote was 8-4. They didn't have a verdict, and they would have had to get a new trial. So this would all be moot. If that juror would have stayed on the jury, it was going to stay 8-4, mistrial, have to do it again. That might make a difference in Judge Schaler's mind with the idea that, if they don't disqualify this juror, and that was clearly at the doing of Anthony Bruno, whether, you want to go in.
That's debatable. I don't know if it's clear, but.
Well, I think Bruno was the one that made the case. He was the one, I think, the way he described it, and who went to the judge. And
well, he's the foreman, so of course he's going to go to the judge. But I think there was some frustration on part of the other jurors that there was a language barrier there. So I don't know how much blame we can directly put on juror number 2.
I think he just made the point, though. He made the point, and if they don't disqualify that juror, it was going to be 8-4.
Yeah.
So I could see Judge Schaler kind of splitting the decision and giving one side, giving McNair the yes, juror Bruno should have probably not been on the case, and 2, we're not going to go into. And the second part doesn't matter. If he finds that Bruno should have been on the case, they get a new trial. So they can decide the next part at the next trial. They don't have to decide the second motion once they get a new trial. And I think they at the end, they said, yeah, that's true. I mean, so they'll just hold off the final decision from the spring is just in abeyance, they said, until they decide either one. If they get either one in McNair's favor, he gets a new trial.
Which is crazy. It feels like this is just the never-ending saga of Todd McNair. But if Judge Schaler does not rule in favor of Todd McNair in either motion, is this the end of the road for McNair?
I think it can still go to the California Court of Appeals. And this would seem to be the kind of case that if you're the California Court of Appeals, you want to decide a case like this. This is a chance to make it more clear exactly what the difference between applied bias and actual bias is. And so I think you would want to take this case if you're the California Court of Appeals, because it would give you a chance to avoid maybe some of what the argument was today, where it wasn't maybe as clear, and make it clear that it doesn't matter how big the law firm is or whether they were in the courtroom on this particular part of the case or not. I think that's what it says, but maybe they need to say it more clearly, which would give them a chance to do that.
Yeah. Alrighty, well, any final thoughts before we wrap it up here? It was a little odd being back here at the courthouse. We both agreed it was a little strange, but any final thoughts before we wrap it up?
Well, I think the final thought is Todd McNair won a big verdict today with getting hired by the NFL. And if you had to choose any one thing that would happen for Todd today, maybe, because we didn't know if we were going to get a decision today. We didn't know if there'd be a preliminary decision that the lawyers would know about, say, late last night. That didn't happen, but getting Todd a new job and seeing how the NCAA people reacted makes you feel good about that part of this case, that there's really a human being there that's had to suffer an awful lot, and for him to have it come around in his favor. I mean, went back to coaching high school this year and did a wonderful job, and wish we could have gotten out to see some of the games, but I know his attorneys did, and that they were just thrilled to death watching him back out, coaching high school. And now to get to see him back with his old coach, coaching in the NFL, that's just, that's really good news.
Yeah, great news indeed. But just to reiterate, Judge Schaler did not rule today. Todd McNair's lawyers do expect that to come in the next couple days, but we're just waiting on Judge Schaler. So be sure to stay tuned to that. But for Dan Weber, I'm Keely Eure. For more, check out uscfootball.com.